17th, 2000, whatever this is, 25.
What year are we on?
Yeah, yeah, right.
What years is this year?
Zoning Board of Adjustment in Madison, New Hampshire. So we have one item on the agenda, well, one case on the agenda tonight and a couple other small administrative points. So Doug, why don't you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so question is whether we have a motion to rehear case 20,
20.
yeah,
2320.
2320.
You need to do a roll call.
Right. Do we need to do a
I
roll
don't know,
call?
it's on the agenda.
We don't have any alternates to elevate.
No. No, so
Okay.
yeah. So, in any event, so there's 4 of us here and we're all regular members, so that's,
And we do constitute a quorum.
and we constitute a quorum, right. So, the question is whether or not to rehear case 2320. And the first, okay, just for the record, there's nobody here anyway, but this is a public meeting, not a hearing. So this is our meeting. The first thing we need to establish is, only because just counting days on the calendar, it appeared that this motion might have been filed late. We've determined that it's not been filed late, and I'd actually like to go on record as saying why it's not late. So, Kate, can you run the timeline? We made the decision on July 16th. So the 17th was the first day of the 30-day appeal. And so then it had to be filed, when did it actually have to be filed? Technically by the 17th of, or by the 16th?
Yeah, I got your calendar up, hold on, I don't have a calendar, I'm sorry. I wasn't prepared that I was doing this.
Well, it technically should have been filed on as I recall.
On the Friday,
Friday,
correct.
which was August
15th.
15th.
Right.
Right,
However, the office is normally closed on the 15th, and so that counts effectively for this purpose as a holiday, which means the next business day is the 18th. And the paper, now the 18th was when you received the paper, right? And you received.
I actually received the FedEx on,
18th. The 18th at 12,
It's stamped the
well,
18th.
he emailed me a copy on the 15th, like he usually does, and then this was received on the 18th.
Okay, so point is that the paper was received on the first business day after the 15th, because the office was closed 15, 16, 17. So, should someone want to count this and say we were granting a favor, the answer is no. It is technically filed inside the framework. What day did we sign the decision letter?
On the 16th. Yeah,
The 16th.
Did I sign it the next day?
the 16th. You have
Oh.
dated the 16th.
Okay, that's fine.
Yep.
Yeah, I just want to make sure there wasn't an additional reason that
No.
yeah, okay. Okay, so then his, we're familiar with his arguments. Rich, since you're new with this, typically, there's only a couple of grounds in which we would grant a rehearing. One is if there's a procedural error that has been brought to light. One is if there's an error of law, which of course he says there is. Another reason would be if new information has come to light that we didn't have available at the time when we made our first decision. And then, independent of reasons on the side of the applicant, the board is allowed to make a determination on its own for whatever reason it feels that we didn't, complete a procedure, or we didn't consider information or whatever, we are allowed within the 30-day period to also make a determination that we wish to do a rehearing. Okay, so, does anybody, now, these are fairly standard arguments that he's used through the whole system.
It's all boilerplate.
Right, and his primary request was on the basis of requesting a grandfather status as an existing non-conforming use, based on the fact that he was, excuse me. So he requested this non-conforming, pre-existing non-conforming status based on the fact that he was financially vested. And we determined that the only evidence of financial investment was a pre-approval of a loan, which was too general. So the question is, did anyone see new information or what we would consider to be an error of law in his arguments?
No, I think it's fine. I mean, I think we are fine. It's nothing new there.
Sharon?
I find no procedural error, no error of law, and no new info that was not available at the first decision.
Rich, do you?
I agree.
Okay. Do you have any reasons why we, as a board, would prefer to rehear this case?
No.
No.
No, okay. Since we have in existing cases that are going to court the same arguments, I don't think it's necessary for us to detail each of these items. Disagreement on the point of law is another issue, but we don't think we've made an error where we've made decisions before them. Do we have a motion to deny the rehearing?
So moved.
Seconded.
Okay, all in favor?
Aye.
Aye. Okay, so we are going to deny the rehearing for case 2023, which was filed.
23.
23,
That's okay, I'll keep you going.
Sorry. Case 2320, which was filed on time. So, okay, that settles that.
That's how you want me to write it?
Yeah, yes, because I could see that somebody might, somebody might call us on that date
We're not
because.
doing any because or anything, or?
Well, this is not,
Okay,
Yeah.
I'm just making sure.
I mean, if we wanted to, we could put because we found no procedural error, no error in law, and no new
Yeah,
info
that
that was
makes sense.
available.
I think we
yeah, go ahead, yes.
found no
No procedural error,
Yep.
no error of law,
No indisputable error of law. I
No,
mean, we
what-
disagree.
yeah,
No what?
no indisputable error of law.
And no new information, right?
Right.
I think we should have that in there.
Right,
Thank you
and
both.
you already have in the minutes that it's the cases, I don't think we need to say again in the decision letter that it was filed on time, but if, as long as we've got that in the minutes, that's fine.
I can put it in there, I'll add it, just,
All right, that's fine.
and then you gotta vote on it.
We did.
We just did.
Oh, I'm sorry, I was writing down the things, I'm sorry.
We voted, it was
Unanimously.
unanimous.
Okay,
to
thank
deny
you,
the- to deny.
sorry. I was writing down all the other stuff because I was interrupting you with because.
Okay, so the next item of business then is the approval of the draft minutes.
I only had that one
Yeah,
change
gentle.
from gentle to gentile.
And then I had a question, Drew,
Yeah,
on page 4 of 6,
okay,
where you put under the second bullet item on the top of the page. And in brackets, you have, we discussed the unique characteristics of the property, but that fits in .5 hardship.
oh, just a second, where, what line are
Sharon,
we?
can you show them it's the dot,
No,
second
there-
dot?
There.
Yep,
Second dot,
No, yeah,
We
second dot.
discussed the unique characteristic of the property, but that fits in .5 hardship.
did you want me to just leave that there like that? Because
oh,
I thought it was kind of odd.
well, these are,
When you sent me the rewrite, that's what you had, and I'm like,
Oh, yeah,
I think that's just a comment to you.
yeah, that was a comment to you.
Okay, I can just take that
Right,
out, I'll
just
take
take that out, yeah.
That's what I thought.
Exactly, because the point was, we gotta kinda,
Perfect.
because these things end up, for whatever reason, we've got two different orders of, you know, sometimes they take hardship first and sometimes they
I
take it
know.
last.
That throws me for a
And
loop.
so the result is we sometimes discuss things out of order, and I
I was
think
gonna
that's what
delete
actually
it,
happened.
but I wanted to check with you first
Right,
before I took it
yeah.
out. Okay.
So that goes.
Okay, so that's that, okay.
You have
And,
to do a motion and vote on
yeah, so,
So I'll make a motion to accept them as written,
Second.
well,
Oh,
as
yeah, as
amended.
amended.
Yeah.
as amended, sorry.
That's okay.
You're right.
And I second it.
Okay, all in
Thanks,
favor?
Aye.
Aye, okay, so the minutes of August 20th are approved.
it.
And then on the administrative items, let's just review what the change was to our procedure to see that it's done the way we intended to have it done.
The other way.
So Kate, you wanna read? That's on page 5 of 6, right, under records? No, it's not,
It is.
hold it, it's, no, it's not there, it's,
Yeah. Here, under appeals, footnote 1.
Yep, it's on page
yeah,
5
yeah,
and 6.
yeah, exactly, appeals, I was looking.
So, under number 6 appeals, I have a footnote number 1, at the bottom I wrote footnote number 1, in the event of the 30th day is a non-business day, the filing date defaults to the next business day, which is why we were talking about previously.
Right,
And then, if that meets with your approval, I will post it, but I did not wanna post it, I know it was nothing
no, I,
that you had to vote on or anything, but I just wanna make sure everybody's in agreement with what I did.
yeah, no, I think that, the point is, there's no change in anything, because
Nope.
that's been standard procedure for the
Right.
town to have Fridays closed, and we're simply acknowledging that we are counting that as a closed day.
Just clarification.
Right,
But I believe that where the 1 is will lead people to believe that we have influence on that 30-day appeal of motion. I think that 1 should be following in the line that says this 30-day period shall be counted in calendar days beginning with the date following the day upon which the board voted to grant or deny the application. 1, footnote 1 there. Because if you put it at the end of the whole appeals thing, we have no jurisdiction over an appeal of a motion for rehearing shall be filed with the Superior Court within 30 days.
Good point.
I'll put wherever you want me to.
okay, where were you suggesting to put it?
I'm suggesting that it goes after the sentence that says this 30-day period shall be counted in calendar days, beginning with the date following the day upon which the board voted to grant or deny the application. Footnote 1.
Footnote 1, in the event the 30th day is a non-business day, the filing date
Add
defaults
that
to the
right
next
in there
business day.
before the RSA,
Yeah,
Yep, put the
yeah.
1 right
Mhm.
before the RSA.
and then put that whole sentence that I had down at the bottom? Is that
No,
what-
just leave
oh.
it at the bottom. You can leave it
Oh,
down at the
okay,
bottom.
Well, the footnote is fine.
Yeah, we're just
Okay.
moving the number.
We're just moving the number, yeah,
Yeah.
so that
Okay.
it's in a logical place
Perfect.
in the,
That works for me, okay.
right.
Phew.
and also for the record here, that appeals section was already read 3 times and entered into our procedure, so,
And we just read it again anyway, so.
right. Well, the point is that, yeah, we're not, yeah.
Yeah.
Okay. Okay, then there's only, I think only one other short item of business, and that is, well, a couple, 2 more short items. Officially want to thank on the public record Jennifer Scaife for her service, and she has, for personal reasons, needed to resign because she's leaving Madison. Okay, so she's technically no longer qualified to be here, and so she, anyway, if you're seeing this, Jennifer, thank you.
Thank you.
The other thing I wanted to mention is that we do have a request that's a little bit up in the air, only because we have a joint meeting for the cell phone tower case, which is on the docket for the 15th of October. 15th?
Yes.
Yeah. So originally there was a request for us to join the meeting on October 1st. And since this is still a little bit in progress, the tendency at the moment is for their attorney to request the planning board to meet with us on October 15th. Since we're all here, I want to find out, are you available in the event that it flips back to October 1st? Could you come to a special meeting on October
Depends
The
1st?
on
first was the date that you would have requested in the email, right?
Yes.
And then the
Okay.
attorney for the tower changed that on me last.
Now, this is the
Okay.
new cell
Yeah,
tower
This
or
is
the?
the,
Yeah.
this is
No,
the
no, no.
new
This is new
application.
cell tower, yeah.
New application.
Which you
Yeah.
haven't all seen yet because I haven't distributed it yet.
Right, and the point is
Don't do
that
it.
we can't discuss the merits of that case because there's nobody here.
Right.
So
But we
October,
can't
October
discuss
first,
the scheduling.
you're talking about October first?
October 1st will probably not happen for you to go to because he changed it now. He was originally going to, he got his application in
Okay.
on September 3rd before the planning board's cutoff date, which was the next day at noon. Then he decided last week, I wanna go to the zoning board instead, so now I want the ZBA to hold the meeting and the planning board come to the ZBA after I already had you guys going to the planning board.
Do-
All right, but I just want us to pencil in the October 1st because this hasn't
I
been
will let you
decided.
know.
I know, since it hasn't been decided, I just want people to say, we might have to meet on the October 1st.
So,
Stay tuned.
may I ask a question?
Yeah,
What purpose does a joint planning board ZBA meeting achieve?
That's what he requested, I don't know.
well, what I would,
It's up to the boards to decide, not me. I mean, it's the chairman, actually.
well,
You and Mark, well, not Mark, but
yeah, well, well, if they want to come to the 15th, and then I guess part of the question is, we, as a zoning board of adjustment, are deciding on a variance request, which is actually only a small piece of the big picture, and this decision is fundamentally a planning board decision, right? So, the answer to the question, what purpose does it serve? It means that the presenting party doesn't need to present all of his points multiple times. So he can present all the points of the argument to both boards at the same time, even though we won't be able to have much of a discussion that evening, we won't be able to care,
We
but
can't
the thing is-
deliberate, we can't vote on it, nothing, so.
No, well, we'd be able to interact with him,
Mhm.
but we've never done one, so we'd have to find out whether the public hearing then, we can't, I mean, we can participate in the public hearing, consider that part of our minutes, but then on the 15th, we would be able to interact on that material and clarify other issues and stuff like that if we went on the 1st.
Wouldn't he still have to, for any joint meeting, regardless of what we're hearing, would not the applicant still have to present all of that information at our meeting in order for us to vote and have it be part of our record?
No, because the joint meeting is the opening of the case. That's the point of the joint meeting, is we
But-
both open the case at the same time.
But that would be an official meeting for us as well.
Right, so that changes our schedule and it becomes an official meeting for us. How do we hold an official meeting when we don't do anything? I mean, we can ask questions.
Well, he enters the information that he's provided.
So we can.
I don't think that'll be your last meeting. I think
We
you'll
have-
have another.
we have-
No, I would imagine,
We
so.
officially listened to it.
I think it's kind of like what Attorney Springer did. Remember he came and gave just he didn't want to really, he just wanted to give you guys a overview of what was going to happen. That's
Right,
what
but
I'm
why do we
thinking.
need a joint meeting to achieve that?
Well,
So I'm gonna go on record, I'm against having a joint meeting.
That's
Because
fine.
I think we don't have any clear direction with regard to procedures, who can vote, who can't vote, what we can vote on, what we can't vote on, what set of minutes does she have to take, because it then becomes an official meeting for us and the planning board, so is it just one set of meeting minutes that indicates it's a joint meeting and it gets filed in both places? I just think it's fraught with us having some mess up. And again, I don't know what purpose it achieves, because the planning board can't decide on a variance, we do. And we can't decide on what the planning board has purview over. So I'm not sure what purpose it achieves. I believe going to the planning board first was probably the right decision. for them to go there.
Well, then it may make the procedure easier for him, since he only has to present all the detail once, and then we can discuss it at our regular 15th meeting, but at least we're there to hear it.
2 weeks later.
Yeah.
Which we're gonna ask him the same questions again in all probability, because in 2 weeks, you know, details fall out. And we probably won't necessarily have the meeting minutes from that meeting by then.
But 2 weeks, if the details are falling out within that 2 week period, it gives us better data to talk about.
No, I think you're misunderstanding what I mean by details falling out. Like,
Okay.
the details fall out of my head and I have to ask them again anyway.
Okay. All right.
Okay, so Sharon has officially admitted to the fact that
That
this is
I'm
a
old.
sieve.
This is a sieve. It only holds so much. My hard drive is pretty full.
Okay, well, okay, so you're against a joint meeting?
Yes, I have no problem going to the planning board meeting to listen to what he has to present so that we are in the know when it comes to our meeting. But I don't think, from a procedural standpoint, that we have any clear guidance on how to even hold a joint meeting, and I think that it
Well,
doesn't achieve anything.
So we don't know if we have, because we haven't ever investigated that. My suggestion was that we need to ask the two attorneys, that is, the planning board's attorney, to talk with our attorney, Tim, in this case, gonna continue, to decide whether we have the option to deny the request and whether that's a good option or not. What we don't want to do is make a procedural error that will cause a snafu later on.
Yes,
Okay.
And that's exactly what I said
that's
to
what I'm
him
concerned
yesterday.
about. Right.
When he called me again and wanted to know what's going on, I said, I'm sending an email to the planning board attorney because I don't wanna get in trouble on a procedure error on my end. And
Right.
he respected that when I said that.
Right, so, it's fine for you to go on record and say you don't see purpose for it, and you can be against it.
Yeah.
My suggestion, though, is that we get clear indication from both attorneys as to whether or not it's an advisable or an optional or a required, event. And if it's advisable, then we should just take their advice. If it's optional, then, I agree, I don't see any reason to sit in another meeting.
So
Um,
my concern is our meeting is tonight. We don't have another meeting until October 15th.
Right.
Would we need, procedurally, would we need to vote to approve to go to a joint meeting? And if so, then when does that happen? Because we don't have another meeting until the 15th.
Well, that's just, the answer to the question is, we don't know, because we've never addressed this question, and I just got back from a trip, I didn't have time to go through the routine. I tried to give Chris, well, it was a mistake, I tried to give Chris a call tonight because, just to get a quick answer on that, but I
Right.
realized, wrong attorney. But I think our answer is, we want to be procedurally correct.
Correct.
And so therefore, we
You
will.
don't have to have a joint meeting, you can decide, the chairmans can, from when I talked with Tim last week, the chairmans can decide whether they wanna have a joint meeting or not, that's between you and Mark, well, not Mark, it's gonna
Well,
have to be
it's the
between-
other Mark.
The,
Paul Marks.
whoever's the
Paul.
acting chair of the
Paul
planning
Marks.
board for that.
So you two would be the ones to decide whether you wanna have it.
Okay, well, if it's our decision and based on the advice of the attorneys, then I'm happy to make that decision with Paul.
Paul, yeah, because, I mean,
Right.
he said to me yesterday that he would defer the planning board meeting on October first, cause he wants to come to the zoning board first, so he will write a letter to the planning board and defer the application, so I wouldn't even, they wouldn't even open it on October first or talk about it till they come to to you first, and then they go to the planning board on November 5th, whatever it is.
Okay, well, I mean, like I said, you won't be here anyway, so you won't have
Me?
to.
No, but I could zoom in.
Yeah, you could. Which might be advantageous just to know that,
Right.
what's going on. Okay, so that's kind of the status of it. Any other comments?
Could we take a provisional vote to say, yeah, we'll go if the information from the lawyers turns to advise us to go?
We can take a straw poll to see how
Yeah.
people are feeling. I don't wanna go on a record as having made a decision on an item for which we don't actually have a legal basis.
Which is why I said provisional vote.
Yeah, okay.
Can I make one more comment? In the last in one of the last meetings that we discussed a previous application regarding this subject, one of the things that we specified and we talked about was the fact that based in our zoning ordinance, while it doesn't specifically declare that you need to go to the planning board first, it's pretty much looks like you should go to the planning board first in order to answer some of those questions that we had that were not presented to us regarding any other locations and all those other kinds of things that would get presented to a planning board. We discussed that in that last case, and I think that it's important to remember that and why we said those things, because they're equally probably applicable here.
I can see both sides to this argument that you're right, that if I've got a project and I need to get planning board approval, I need to go to the planning board, so they can say, this is wrong, you need to go to the ZBA. The other side of the argument is, like Drew, I know what some of the problems are going to be, so I can go to the ZBA first and get their approval before I go to the planning board for them to say, go back to the ZBA.
Except, I guess to me, I believe that the planning board, which writes the zoning ordinances, does the master plan for the town, creates those specifications with regard to whether or not you can, and approvals for whether or not you can do a planned urban development or any of those other kinds of things. I truly believe that their approval of a project first, that yes, we can have that project in this town. Now, if the specific piece of property you're looking at requires ordinances.
Variances?
Or variances, ordinances. I as the planning board would say, we agree with the concept of having this type of situation in town and recognize that this is the best place for it, given all your other alternatives you've presented. If this, parcel A is the only place you can put it, now you need to go to the zoning board and see if you can get that variance.
Yeah, but it works both ways.
I don't see it. In my mind, it doesn't work both ways. In my mind, I don't say it on camera, the planning board is a bit of a higher authority than we are. We're the adjudicating piece of what the planning board develops.
But me as an attorney can see the rules of what we're doing and know that I need a variance to do this.
Right.
So I don't need to go to the planning board to tell them, to have them to tell me to come to the ZBA. Let's go to the ZBA first and short circuit the process.
But I think that's the point right there, they're short-circuiting the process.
Correct. The
Because
process has to play
the
itself
very
out.
questions that Sharon brought up have yet to been asked or answered.
But I'm not saying that they're circumventing the process. All I'm saying is they're getting ahead of the game if they know that they need to do a certain thing. And that's all.
Okay, but if we listen to, let's say, location A, and we make decisions based on location A, and then they go to the planning board, and the planning board says, well, did you look at other locations? And all of a sudden, they're gonna have to come back anyway if the planning board says it should be location B.
But that's a big if.
Right.
Then it comes back to you because the data has changed. But if the data hasn't changed and we give them the variance for place A, and the zoning board, the planning board says, oh, you've already got this variance in case, good, you get our approval, you don't have to go back to the.
But they should not be approving a project based on our variance. They should be
Why?
approving the project based on it fitting the master plan, it being in accordance with the ordinances, it being in accordance with the, what the town wants to have happen. Again, I believe the planning board is a higher construct. We are that adjudicating piece to it. We're the judge and jury, so to speak, for the variances. But to decide whether a project fits in a specific parcel resides with the planning board, and in my mind, that comes first.
Yeah, we'll agree to disagree.
Okay.
And I think the reason why he was doing this joint thing is because he doesn't wanna go to the planning board on the first, because he wanted to have the balloon test done. So he's already scheduled
That's
the
what it
balloon
is.
test
That's
for
what it is.
October 6th.
Right,
That's the first day. If it doesn't, if the weather is bad, as we know from the last
Right.
one, it'll be the next business day or the next business day. He's already done his posting and already sent me it to send out with all of my abutters notices, so I can send that out so people get that as well. But I'm like sitting here saying, I need to process this. It is a viable application in front of me, and I need to get out abutter notifications because time is of the essence for me. So that's why he was writing on the balloon test. He didn't have enough time to do it when he submitted the application on September 3rd. There wasn't enough time for him to schedule the balloon test. So now this gives him another couple weeks
That's,
till he comes in front of you folks.
that's what I think it is.
well, the reality is, like I said, the application has been submitted and stamped. That starts our 90-day clock.
I did not accept it on day one though because there was no abutters list. I said,
It wasn't